Why is proving third-party workplace negligence so difficult? Imagine trying to solve a puzzle where some pieces are missing and others are hidden. That's what proving third-party negligence at work can feel like. When someone outside your employer causes your injury, it's not always straightforward to show they are responsible. Unlike workers' compensation claims, which are automatic and no fault, third-party claims requiring clear proof that a specific third party owed a duty of care, broke that duty, and caused your injury. One big challenge is establishing that the third party had a legal obligation to keep you safe. For example, if a contractor or equipment manufacturer failed to maintain machinery properly, you need to prove they had a duty to ensure safety. Sometimes, these relationships are not obvious, especially if the third party is a subcontractor or a maintenance company. Next, you must show they actually breached that duty. This involves technical investigations, like examining safety protocols, maintenance records, or safety audits. If a piece of equipment was faulty, you need proof that the manufacturer or repair company did not follow proper procedures. This can be tricky because it often requires expert analysis to determine if negligence occurred. Proving causation is another hurdle. You have to connect the third party's breach directly to your injury. If multiple factors contributed to your accident, or if your employer's own negligence played a role, it becomes harder to prove that the third party was the main cause. For example, if a piece of machinery malfunctioned and caused injury, you need to show that the malfunction was due to negligence and not just wear and tear. Gathering strong evidence is essential. You'll need detailed documentation like safety reports, maintenance logs, or medical records. Sometimes, expert witnesses such as engineers or safety specialists are needed to explain how the injury happened and who was negligent. Without this evidence, courts may find it hard to hold the third party responsible. Legal procedures also make things more complicated. Third-party claims are personal injury lawsuits, which requiring meeting a higher standard of proof than workers' compensation. You, as the injured worker, carry the burden of proof. That means you need enough evidence to convince the court that the third party was negligent. Third parties often defend themselves by arguing that you or even your employer were partly responsible. This is called comparative or contributory negligence. They might say you ignored safety rules or that your employer was at fault, which can weaken your case. Finally, workplaces are often busy and complex environments. In industries like construction or manufacturing, many people, machines, and safety rules are involved. Identifying the exact responsible third party and proving their negligence among all these factors is a real challenge. All these reasons show why proving third-party negligence at work is not easy. It takes careful investigation, solid evidence, and sometimes expert help. That's why legal guidance is often needed to navigate these claims successfully. While third-party claims can offer broader compensation, including pain and suffering, they demand a higher level of proof and more complex legal work.